Good morning, friends. I am K. Pattabhirama Rao, Assistant Professor, National Judicial Academy, India, situated at Bhopal. The topic on which I am speaking now is on pre-trial process role of magistrates. The learning objectives of this session are: number one, to make the learner understand the various functions the magistrates perform during the pre-trial stage. Number two, to make the learner understand the importance of the protection of the rights of the accused during the pre-trial stage. Number three, to make the learner understand legal provisions relating to the role of magistrates during the pre-trial stage. With these three learning objectives, let us commence discussion. And the stage is pre-trial stage. And what is meant by pre-trial stage? Before commencing my talk, I want to clarify what is pre-trial stage. In cognizable offences, the police can register and investigate the cases without the permission of the court, whereas in non-cognizable offences, the police need to obtain order from the competent magistrate under section 155(2) of the Code of Criminal Procedure, and then they register the case. The stage between registration of the criminal case and commencement of the trial is known as pre-trial stage. Now the question comes, when the trial begins. When we look at the scheme of the CRPC, the process of discharge and framing of the charge are also considered to be part and parcel of the trial. In actual practice, however, the courts consider the commencement of recording of evidence of the prosecution witnesses as a starting point of the trial. The day on which the evidence of the first witness of the prosecution is recorded is starting point of the trial in actual practice. Generally, the magistrate deals with all criminal cases initially, whether or not he is competent to try the case. If the offence is exclusively triable by the court of session, he commits the case to the court of session. Otherwise, he himself proceeds with the trial of the case. And there are special acts, special courts established under special acts, and in such cases, even the court of session act as court of original jurisdiction, and all the proceedings in such special cases commence in the special courts. In all other cases, all the proceedings are commenced in the court of magistrate, and in all these cases, magistrate acts as supervisor of the investigation. CRPC provides for independent investigation by the police and non-interference by the courts. This is the original idea. However, to sustain the fairness in investigation and to protect the rights of the accused, certain powers are conferred on the courts. The role of the magistrate, very rightly described by the Law Commission of India in 41st report. Magistrate is kept in picture at all stages of the police investigation, but he is not authorized to interfere with the investigation or direct the police as to how the investigation is to be carried. The oft-quoted judgment is King Emperor versus Khwaja Nazir Ahmad. This judgment was rendered by Privy Council in the year 1945. In this judgment, it was held that the functions of judiciary and police are complementary, not overlapping, and the combination of individual liberty with the observance of law and order is only achieved by leaving each to exercise its own function. This judgment, which was given before the commencement of Constitution of India, was later considered by the Supreme Court. In H.N. Rishbad versus State, as well as in Abhinandan Jha versus Dinesh Mishra, the cases which were decided in the year 1955 and 1968 respectively, the Supreme Court endorsed the principle which was enunciated by the Privy Council in Khwaja Nazir Ahmad. And the legal position is this: normally the court shall not interfere with the investigation by the police. In cases of the grave injustice or unnecessary harassment, the High Court can pass orders under Article 226 of the Constitution or under 482 of CRPC. To be more comprehensive on this topic, I would like to discuss the role of the magistrate during pre-trial stage under two heads. Number one, in cases instituted on police report, and number two, in cases instituted otherwise on police report, that is complaint cases, are normally known as private complaints. In the cases instituted on police report, police register first information report under section 154 CRPC. Under section 157 CRPC, the police has to send the FIR to the magistrate immediately after registration. The magistrate authenticates the date and time of the receipt, and it gives a clue as to the time of registration of the FIR. Many of you may be knowing the evidentiary value of FIR, and if the registration of FIR is delayed, unless the delay is explained, court suspects the genuinity of the FIR. And this is the first interface between the police and magistrate during the pre-trial stage. Later comes the stage of arrest. When a person is arrested during the course of investigation, the normal rule under section 167 CRPC is that the investigation should be completed within 24 hours. If within 24 hours the investigation is not completed, the police have to immediately produce the arrested person before the nearest magistrate. The magistrate need not be the person who is competent to try, he should be the nearest magistrate. And when a person is produced before the magistrate can order his detention, and according to 167 CRPC, the detention can be in such custody as the magistrate thinks fit. The words "in such custody as the magistrate thinks fit" are very important. This gives two kinds of custody. The magistrate can authorize the custody, either judicial custody or police custody. What is judicial custody? The moment a person is produced before the magistrate, all the records and connected papers are also placed before the magistrate, and after perusing them, if he satisfies that prima facie case is made out, he orders that the person be kept in custody in the jail. It is called judicial custody. In judicial custody, the person is in the custody of the court, in the custody of the judiciary, in the custody of the judge who passed the order, and during this stage police has no access to this person. They cannot meet him, they cannot question him. This is judicial custody. Then what is police custody? In many cases, after producing the accused and sending the person to the judicial custody, police persons file applications before the magistrate seeking for police custody of the person on various grounds. They may ask that this person is required for questioning, this person will give information, and several reasons. They delineate all the reasons in the application and they place it before the magistrate, and the magistrate, if he thinks that police custody is necessary and warranted, he orders for the police custody. And 167(3) CRPC mandates that the magistrate who is ordering the police custody shall record the reasons as to why he is granting police custody. In Madhu Limaye 1969 case, the Supreme Court observed that the magistrate cannot mechanically pass orders granting the police custody, and he has to give reasons as to why he is granting the police custody. And what is the period during which the police custody can be ordered? This question came before the Supreme Court in CBI versus Anupam J. Kulkarni, a case which was decided in the year 1992. And interpreting section 167(2) CRPC, the Supreme Court held that police custody can be given during the first remand only. According to section 167, a person can be remanded to any custody only for 15 days. Remember, in all the cases, the first remand should be judicial custody, and only after remanding a person to judicial custody, the police custody can be ordered. And in Anupam Kulkarni case, which I refer to now, it was held that the nature of the custody can be altered from judicial custody to police custody, and vice versa. during the first remand period only, and after that the custody shall only be the judicial custody. And while ordering police custody, the magistrates usually impose a number of conditions. The conditions that can be imposed for grant of police custody can be like the person should be subjected to the medical examination before commencement of the period of police custody and immediately after expiry of the period of police custody. A lawyer presence should be allowed during the police custody along with the accused at the time of interrogation or questioning the arrestee. And further, the courts also impose a condition that if medical assistance is required, that should be immediately made available to the person, and a number of conditions can be imposed basing on the circumstances of each case. What is the requirement of lawyer? In the Nandini Satpathy case, a famous case, Nandini Satpathy versus P.L. Dhani, the Supreme Court considered this and it held that presence of lawyer is necessary for the purpose of alerting the accused about the incriminating questions. The accused has a right not to be compelled to give answers to the incriminating questions under Article 20, Clause 3 of the Constitution. Therefore, presence of lawyer is necessary to alert the accused during police interrogation to understand the questions which are having incriminating nature. And after custody, if bail is granted, he will be released. If bail is not granted, the custody of the arrestee is extended from time to time, but always that is judicial custody after first remand, after first 15 days. Under section 436 CRPC, in all cases of bailable nature, the accused case is to be released, and it is as a matter of right the accused can claim the bail. However, the court can ask the accused to furnish the sureties. In any case, if any person due to poverty or any other reason is not able to furnish the sureties, within 1 week the person is to be considered as indigent person as per the proviso added to section 436 CRPC, and such person shall be released on execution of a self bond. 437 CRPC of course governs the rules relating to grant of bail in non-bailable offences. Since there is another session on bail, now I will skip to other functions the magistrates discharge before commencement of the trial. Recording of confessions and statements. It is an important function which the magistrates discharge before the trial. Under section 164 CRPC, any magistrate or metropolitan magistrate can record the confession of the accused or statement of the witnesses. Section 164 CRPC has elaborately prescribed the procedure for recording of the confessions. It insisted that magistrate shall satisfy that the confession is being made voluntarily. This satisfaction is of utmost importance. Apart from this, it is obligatory on the part of the magistrate to forewarn the accused, informing him that he is not bound to make any confession, and if confession is made, that will be used as evidence against him. This warning should be given, and the magistrate should append a memorandum after recording the confession of the accused, and in that memorandum he shall categorically state that the accused was informed of the rules and accused was warned that he need not make any statement, and if he makes the statement, it will be used in evidence against him. This memorandum is also very important, and while recording the statement of the accused which is in the nature of confession, the magistrate has to follow the procedure prescribed for the recording of the statement of the accused under section 281 CRPC. And the other function that magistrate performs is recording of statements of witnesses, and while recording the statement of witnesses, the magistrate has to follow the procedure of recording evidence of witness. during the trial, and oath is to be administered. And in this case of recording of statements, no confession rules are applicable. And after this, another important function is power to order investigation. Section 156(3) CRPC says that any magistrate empowered under section 190 may order investigation. Under section 190, the magistrate can take cognizance of the offences, and therefore if a magistrate who has power to take cognizance of offence can order investigation into any criminal case, it can be either cognizable case or non-cognizable case. Under 156(3) class CRPC, if the magistrates order investigation, it is the bounden duty of the police to register the FIR, investigate it, and file final report. However, as I mentioned it in the beginning itself, in Khwaja Nazir Ahmad case decided by the Privy Council, it was held that the duties of the magistrate and the police, they are not overlapping and they cannot cross the swords with each other at any time. An important and very interesting case came before the Supreme Court in Popular Muttaya versus State in the year 2006. In this case, while recording the evidence of witnesses, the session judge has categorically recorded that the involvement of certain persons who are not accused in the case was also stated by the witnesses. The witnesses categorically stated that apart from the accused, two more persons involved in the offence against whom the police did not file the charge sheet. However, the session judge convicted those accused who were charge sheeted by the police, and when the convicted accused approached the High Court of Madras against their conviction, the High Court ordered the police that fresh investigation is to be conducted and case is to be registered against the two persons against whom the witnesses spoke, and they have also ordered that the investigation is to be carried out by CBCID of the state, and public prosecutor is to be consulted for necessary legal advice. Then the persons against whom such orders were made approached the Supreme Court, and Supreme Court, one of the persons is Popular Muttaya, and Supreme Court in this case heavily came upon the High Court and made the observation. The Supreme Court said, in the instant case, not only the High Court had asked reinvestigation into the matter, but also directed examination of the witnesses who had not been cited as prosecution witnesses. It furthermore directed prosecution of the appellant, which was unwarranted in law. Therefore, this is an indication as to how the powers of the magistrates are to be exercised. They cannot order for prosecution of any particular person. They cannot direct the police to file charge sheet. However, we find another judgment in the year 2008 rendered by the Supreme Court in Sakiri Vasu versus State of UP. In this case, again the powers of the police under section 156(3) fall for consideration. Contrary to what was stated in Khwaja Nazir Ahmad and later in Popular Muttaya, Supreme Court observed that section 156(3) provides for a check by the magistrate on the police performing its duties under chapter 12 CRPC. In cases where magistrate finds that the police has not done its duty of investigating the case at all or has not done it satisfactorily, he can issue a direction to the police to do the investigation properly and can monitor the same. The Supreme Court further observed that section 156(3) CRPC is wide enough to include all such powers in a magistrate which are necessary for ensuring a proper investigation, and it includes the power to order registration of an FIR and of ordering a proper investigation if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police. Section 156(3) CRPC, according to this judgment, is wide and it will include all such incidental powers as are necessary for ensuring a proper investigation. This judgment is contrary to a consistent view that has been upheld by the Supreme Court, basing on Khwaja Nasir Ahmad, that the magistrate shall not interfere with the investigation. Further, it is not clear what exactly is the proper investigation. In such cases, the complainant, whenever he feels dissatisfied or whenever he feels that he can take revenge against the accused or any persons against whom he has grudges, he can ask the police repeatedly, or he can come to the magistrate under 156 class 3 CRPC asking further investigation, and as per this judgment, the magistrate has to give the directions for proper investigation. In fact, the proper investigation has no parameters, and it would be difficult for a magistrate at the pre-trial stage to find out whether the investigation is proper or whether the investigation is not proper. However, this judgment is the precedent, and the rationale of this judgment was in fact challenged by some of the parties in Supreme Court in some other cases, but still the judgment is continuing as binding precedent. And apart from ordering investigation, the CRPC provides for stopping of the investigation in a limited category of cases. In cases when investigation in any summons case could not be completed within 6 months, the magistrate usually issues a notice to the investigating officer asking him as to why the investigation could not be completed and why he could not stop the investigation. And if the investigating officer comes to the court and gives reasons as to why the investigation could not be completed and satisfies the magistrate regarding the reasons for non-completion of the investigation within the prescribed period of 6 months, the magistrate either can allow the police officer to continue investigation, or if he is not satisfied, he can order for stopping of the investigation in such cases. Even in such cases where the magistrate ordered stopping of investigation, the session judge can order further investigation, and this is provided under section 167(5) CRPC. And now I will come to the cases which are instituted otherwise than on police report. Suppose a private party comes to the court and files a complaint. These are known as private complaints, and in such circumstances, it is the duty of the magistrate to record the statement of the complainant and his witnesses, and he has to examine all the documents that are filed by the complainant. And after that, if he is satisfied with the material, he can proceed with the case and follow the CRPC and either commit the case if it is exclusively triable by the Court of Sessions, or he can proceed with the trial of the case. But he has another power here. He can require or direct investigation by the police. If the material that is placed before him by way of statements of the complainant and witnesses or other documents is not enough to proceed, he can give directions to the police for further investigation. This power under section 202 CRPC is different from the power under section 156 class 3 CRPC. To exercise the discretion under section 202 CRPC, it is necessary that the magistrate shall record the statement of complainant and statements of the witnesses of the complainant. And further, under section 156 class 3 CRPC, any case can be referred to the investigation by the police, but under section 202 CRPC, if the offence is exclusively triable by the Court of Session, the magistrate cannot refer the case for investigation by the police. And this is regarding the power of the magistrate to order further investigation. Remember, the magistrate, or for that matter even the High Court, does not have power to order re-investigation within the scheme of the CRPC. The power is only to order further investigation. Under section 173(8) CRPC, the police can conduct further investigation even after filing the charge sheet or final report, but that is the prerogative of the police officer and it is the duty of the police officer. However, there are certain judgments in which it is interpreted that the court can direct the police officer to do investigation under section 173(8) CRPC. Now, we come for other functions that magistrates perform in aid of investigation. Recording of dying declarations. Again, recording of dying declaration is a subject which is not uniformly practiced in all the states. In some of the states, the dying declarations are recorded by the magistrates at the request of medical officers, and in some states in our country, the dying declarations are recorded by the executive magistrates. Similarly, test identification period is conducted by judicial magistrates in some states, whereas in some other states this function is being carried by the executive magistrates. But section 311A CRPC, which was introduced into the Criminal Procedure Code about a decade ago, gives discretion to the magistrates to order for specimen signature or handwriting for comparison, and the limitation in this discretion is that the magistrate can order for specimen signature or handwriting of those persons who were arrested by the police. Earlier, when this provision was not there, it was very difficult for the police officers to collect the specimen signatures and prove that the specimen signatures were furnished by the particular individual. With 311A CRPC, the job of the police officer in collecting specimen signature and handwriting of the suspects became very easy. And another function the magistrates perform is sending of samples to the forensic labs. The police collect various materials, and for scientific analysis they send the material to forensic labs, and usually the police on their own can send them, but to make it more proper and to make the evidence more believable in certain important cases, the police channel the samples and other objects through the magistrates. And other important function the magistrate does is cognizance. It is important to note that the word cognizance is not defined. When a magistrate takes cognizance, what is the meaning of the word cognizance? Cognizance means it is judicial application of mind. Cognizance of the offence is the thing which a magistrate takes, but not cognizance of the offender. And the cognizance, once the magistrate takes, then he can make the process. And it is not clear as to whether magistrate takes cognizance of all the offences. In a recent judgment of Constitution Bench in Dharmapal versus State, the Supreme Court held that magistrate does not take cognizance in cases which are exclusively triable by the Sessions Court, and it is only the Sessions Court which takes the cognizance, because under section 193 CRPC, after committing the case to the Court of Sessions, the Sessions judge takes cognizance. But the ratio of the judgment in Dharmapal is not clear. The Supreme Court was under the impression that the magistrate can take cognizance only in cases which can be tried by him, and cognizance of an offence can be taken only once. It is respectively submitted that the judgment may not be fit in all the circumstances. And other important thing, once charge sheet is filed, once the case is before the court, the accused were made to appear before the court, and under section 207 CRPC, it is the duty of the magistrate to furnish the copy of the police report, FIR, and statement recorded under section 161 class 3 CRPC by the police, and similarly the confessions, if any, recorded by the magistrate. In cases which are instituted otherwise on police report, all these documents would be there except police report and FIR. In such cases, the magistrate has to furnish the copies of the statements recorded under section 200, 202 CRPC, confessions or any other documents which are relied upon by the complainant in the private complaint case. And committing the case to the court of session is an exclusive function of the magistrate. And the magistrate, while committing the case, sends the record and also notifies the public prosecutor and sends all the papers and property to the court concerned. And once the case is committed under section 209 CRPC, the accused has to attend the court of sessions and he need not attend the court of magistrate. And once the case is committed or once the copies are furnished, the next stage is examination of the record. The magistrate acting under section 239 CRPC and the court of session acting under section 227 CRPC examines the record, and if after hearing the accused and the prosecution and after examining the documents that are placed before the court, if the magistrate feels or satisfies that there are no grounds to proceed against the accused or the charge against the accused is groundless, he has to discharge the accused. It is the duty cast upon either court of session as well as on the magistrate. And if they are satisfied that there are adequate grounds to proceed against the accused, then the stage comes framing of the charge. The court of session under section 228 CRPC and the magistrate trying a warrant case under section 240 CRPC frame charges. And in summons cases and summary trial, no formal charge is required, but substance of the accusation is to be explained to the accused. And contents of the charge. Section 211 to 214 CRPC describes the contents of a charge. Under section 216 to 218 CRPC describes the procedure for altering the charge. And section 218 CRPC states the general rule that there shall be distinct charges for distinct offences, and of course there are certain exceptions to this rule. According to section 211 to 214 CRPC, the charge should contain all the details relating to the offence, time of offence, date of offence, and all other things. However, if the offence is described with a specific name, it is sufficient if in the charge the name of the offence is mentioned. And there are certain exceptions to the general rule. The general rule is that each offence there should be one charge, distinct offences, distinct charges. However, the exceptions are if the offences are of same kind within 1 year, they can be charged together. Section 219 speaks of these exceptions. There are 5 exceptions, important exceptions. And second exception is that if the offences are committed in the course of same transaction, they can be charged at one trial. This is stated in section 220 clause 1 CRPC. And offences of criminal breach of trust, criminal misappropriation can be charged together as per section 220 clause 2 CRPC. If the same offence falling under different sections under section 220 clause 3 CRPC, the court can frame can join the charges. And act forming an offence also constituting different offences when taken separately. Suppose exposing child, neglecting a child is an offence under section 317 CRPC, and causing death is an offence under section 302 IPC. And if a woman or a man exposes a child, she commits an offence under section 317 CRPC, and if the child dies, it falls under section 302 IPC. In such cases also the charge can be combined. And CRPC provides for alternative charges when it is doubtful as to under which provision of law or under which crime the acts of the accused fall, and the court in such circumstances can frame alternative charges. And after framing charges, the charge is explained to the accused in the language known to him, and he has to understand this is nothing but observing the principles of natural justice. And after that, after understanding the charge, if the accused pleads guilty, the court of session convicts him under section 229 CRPC, and the magistrate acting under 241 CRPC in warrant cases and under section 252 and 253 CRPC in summons and summary cases convicts the accused. But it is to be remembered that courts are not bound to convict whenever there is plea of guilty. The first test is whether the guilt plea of guilt is voluntary or whether it is coerced. Even after coming to a conclusion that it is voluntary in serious cases, the session judges need not be bound by the plea of guilty, and they can proceed with the trial, asking the prosecution to prove the guilt of the accused. Once the accused pleads not guilty, trial commences, and then the pre-trial stage actually ends. So this is all about pre-trial stage process. Thank you.